Are we ready?
Unmute there.
Can you hear us, Jack? Nope,
Nope.
we can't hear you, so hang on.
Radio check, can you hear us now?
There we go. Now we
Yeah.
can. All right. We are back in regular session. Do I need a roll call or anything to go back in?
We could do another roll call.
Okay, roll call, Amy.
Skylar Croft,
Present.
Ms. Craig,
Present.
Ms. Genovese,
Yeah.
Ms. McCrory, Mr.
Yes.
Turbin,
Yeah.
Mr. Brett,
Yes.
Vice Chair Donahue,
Yes.
Chair Watson.
All right. We discussed in closed hearing, 2A24, Shamsi versus Ropp, 25 CD 038. Do I have a motion or a
So-
discussion?
So complainant Shamsi failed to appear. We therefore asked Mr. Rupp, would he prefer that this case be dismissed for want of prosecution, or would he rather it be heard on the merits? He preferred that it be dismissed for want of prosecution. So is there a motion to dismiss 2A24 for want of prosecution?
Moved. Second.
It's been moved and seconded a couple of 3 times. Amy, roll call, please.
Ms. Skylar Croft,
Yes.
Ms. Craig.
Yeah.
Ms. Genovese,
Yes.
Ms. McCrory,
Yes.
Mr. Turbin,
Yeah.
Mr. Brett,
Yes.
Vice Chair Donahue,
Yes.
Chair Watson.
Yes,
Motion passed.
All right, in regard to math 20 or 2A26 Matthews versus Friends of Kathleen Lorenz, 25 CD 040. Marnie?
So we heard from both sides on this complaint, and the general consensus seems to be to adopt, well, if the board votes so, to adopt the recommendation of the hearing officer and the general counsel to find that the complaint under section 9-8.5 for contribution limit violations was not filed on justifiable grounds and should be dismissed. However, the claim under section 9-25 was filed on justifiable grounds and should proceed to a public hearing.
Do
So
I have a
moved.
mo- Second. Been moved and seconded. Yeah. Amy, roll call, please.
Ms. Skylar Croft,
Yes.
Ms. Craig.
Yes.
Ms. Genovese,
Yeah.
Ms. McCrory,
Yes.
Mr. Turbin,
Yeah.
Mr. Brett,
Yes.
Vice Chair Donahue,
Yes.
Chair Watson.
yes.
Motion passed.
All right. Marnie?
Okay, now we're going to talk about some proposed administrative rules. It's actually not on the agenda, but I wanted to provide a brief update on the BREP rules, which have been filed and are in a second notice period now. We just learned that JCAR does not like some of the language we proposed for rule section 100.185C that gave the board the ability to reduce the civil penalty upon good cause shown. JCAR believes there's not statutory authority for that. And I don't disagree with them. So moving forward, the JCAR is going to consider these rules at the June meeting, but they cannot include language that would allow the board to reduce or waive civil penalties because there's not authority to do so. So just letting you know, there's nothing we can do about it, but if we want our rules to pass, that's, we have to, observe what JCAR says, and that is what we will do. So moving into the items on the agenda, we have 2 separate sets of rules to consider. The first is agenda item 2B1, part 216, registration of voters on the address confidentiality program. Staff is asking the board to consider and approve filing with JCAR this amendment to Part 216 of the administrative rules. These proposed rules are new, so there's no previously adopted language being amended. The rules are drafted in compliance with the Address Confidentiality for Victims of Domestic Violence, Sexual Assault, Human Trafficking, or Stalking Act. Related to the work of the board, the Act prohibits the name of any participant in this address confidentiality program from appearing on a list of registered voters. Specifically, Section 30A requires the board to, quote, adopt rules to ensure the integrity of the voting process and the confidentiality of the program participants, unquote. In fulfilling this request, staff have drafted these rules, which broadly establish the framework through which program participants, the Attorney General's office, which administers the program, our office, and local election authorities share program participant information in a manner that is secure and confidential. The rules establish the process through which ACP participants' information is omitted from lists of registered voters as required by the Act and Section 19-4 of the Election Code. It identifies the redaction information of ACP participants from voter registration lists accessible to state and local political committees pursuant to Sections 1A25, 19-4, and 19-7B of the Election Code. And finally, it identifies a process to notify ACP participants of political activities which require disclosure, such as political contributions or signing a nomination petition. And it establishes a framework for the SBE to redact ACP participants' information from these disclosures in the same manner that participants in the Judicial Privacy Act redaction process are treated. So I hope the board has had a chance to take a look at these rules, and we'll pass these rules today for filing with JCAR.
Is there discussion?
Yeah.
Member Craig?
I just want to thank everybody, Marnie, Brian, especially Brian Pryor. We have been going over these, I know, since January. There was a lot of back and forth on these. And I just really appreciate, because I know we talked to our stakeholders, Rick and I both worked on these a lot, and we appreciate everybody's help. So we know we can't speak for everybody that's going to sit on JCAR, that these are going to just go on through, but at least we got a lot of the answers done ahead of time. So I just want to thank everybody for their work on it.
Great. Thank you. And to Jordan Andrew as well.
Yes. Where's Jordan? She's out. There she is. All right. Any other discussion? Do we need a motion? We need to approve Part 216, registration of voters before JCAR. Do I have a motion?
So moved.
Second.
Second.
It's been moved and seconded. Roll call, Amy?
Ms. Bellarcroft,
Yes.
Ms. Craig?
Yes.
Ms. Genovese?
Yes.
Ms. McCrory?
Yes.
Mr. Turbin?
Yes.
Mr. Brett?
Yes.
Vice Chair Donahue?
Yes.
Chair Watson?
yes,
Motion passed.
And Sean Sarku worked on these rules as well. He did the first drafts.
All
So
right.
thank you to everybody.
Yep. We all worked well together. All right. 2A or 2B2, Part 207.
So this is another set of rules. These are miscellaneous computer-based voter registration systems. So staff is asking the board to consider and approve filing with JCAR this amendment to Part 207 of the administrative rules. Like the last one, these proposed rules are brand new without changes to previously adopted language. These rules propose the board exercise the statutory authority in sections 4-33, 5-43, and 6-79 of the Election Code, which govern the computerization of voter records. These sections provide that the SBE shall certify that the computer-based voter registration system used by the election authority complies with the provision of these sections of the code. In furtherance of this statutory obligation, staff drafted a certification scheme for these computer-based voter registration systems. It first establishes minimum formatting and cybersecurity requirements for data contained within and shared by local voter registration systems. It establishes a process to review and certify systems currently in use by an election authority, systems currently in use in Illinois, but not by the requesting election authority, such as if one county would like to use a system that is already in use in a different county, plus new systems to be used by an election authority. The rules establish a process for a biannual review of systems to ensure continued compliance with these requirements, which allows for considerations of changes in the cybersecurity space. The rules notify election authorities that certification is required for continued access to the Illinois Century Network, and that failure to comply may result in disconnection from the Illinois Century Network And of course, they need to be connected to the Illinois Century Network in order to have access to the voter registration. So it's a pretty important thing. The rules set the obligations of election authorities and voter registration vendors in the event of a data security breach. And the rules establish the notification and comment process in the event of revocation of Illinois Century Network access in the event of non-compliance or of a data security breach. So here, VRS, legal, information security, and IT have all worked closely together to ensure these rules adopt standards that not only meet but exceed minimum cybersecurity standards in the marketplace, that will not disrupt agency operations, and that will allow for the continued flow of information to election authorities from the SBE, even in the event of revocation of Illinois Century Network access. And Brian Pryor and Justin Scholes, I believe, are available if there are questions, because this is awfully technical for me.
Do we have questions? Discussion?
Again, just thank you to everybody who worked on these.
Served on JCAR years ago. It ain't easy.
Yeah, no,
So,
thank you for everyone with their technical acumen. I am not that person. So
Thank you all for your work. Do I have a motion?
Motion to approve.
Second.
It's been moved and seconded. Amy,
Ms.
roll
Ball-
call.
Ms. Ballard Croft,
Yes.
Ms. Craig,
Yes.
Ms. Genovese,
Yes.
Ms. McCrory,
Yes.
Mr. Turbin.
Yes.
Mr. Brett,
Yes.
Vice Chair Donahue,
Yes.
Chair Watson.
yes.
Motion passes.
All right. Marnie?
and that concludes my lengthy
Holy
report
cow.
for the day.
Thank you, ma'am,
Thank
for all
you.
you do. All right. Bernadette, you're on.
Okay, good afternoon. So the first item of business in my report is a legislative update. Listing of the current election-related bills and their status has been provided in your packet. At this point in session, there's a lot of them. So if there's any of particular interest or question, Brian Pryor is here. We're happy to go over them or discuss. But as of right now, we're monitoring all of them. This is the time when we're awaiting any elections omnibus bill that might come out, where we have directors at the ready that upon filing, we would review it. As noted previously at board meetings, we've had subject matter hearing for our legislative agenda. Brian obviously has been over at the Capitol advocating for our agenda, and we'll see if that is included. If it is going to be, it would be in an omnibus bill. So just kind of waiting. It's one of those things, I think at any moment it could be filed. Most of us will be at the ready over the holiday weekend too, if it should be. Our goal is to provide any feedback or cure any issues as soon as we can once we see the language. So that is something that we're going to be focusing on over the next, few days to the next week. Other than that, last month we had our appropriations hearings in both the Senate and the House. We fielded some routine questions, but nothing that was, too controversial. It seemed they went well overall. We did minimal follow-up to some of those questions and provided answers in follow-up, but again, nothing too intense. Overall went fairly well. Again, we'll be waiting for the actual budget bill to see what is included and to ensure that everything that we have asked for is in there. So just at the ready to see that language whenever we get it, at the mercy of the General Assembly now for that language along with the omnibus. Other than that, nothing really from me. Brian is available if there's any questions, but again, I know you also, the legislative subcommittee, been monitoring some of the bills along with us, so thank you. And also taking on those rules that we just passed at the same time. So,
Well, I think these two work pretty hard. And Brian, we thank you for all you do because this is a crazy time of the year. Do you have any questions in Chicago?
None.
No questions.
Thank you, Brian. I would just say kind of keep us up to date if something's coming up. So if we're in a position, we could watch it on ilga.gov because sometimes it's interesting to hear the discussion, some of the questioning and stuff. But if anything pops up and you need be ready in the middle of the night. There seem to be night owls around here lately, so be ready.
Yeah.
Do you have anything you want to talk about?
I just want to thank everybody that works with me. I don't do any of this alone, so particularly thank you to George, Maggie, and the team, and both of you. Much appreciated. I'll be on high alert and notify you guys when something is filed. As I had mentioned briefly this morning, I'm going to do my job and then you'll get a notification, but you'll certainly get it.
And I do know that 4 of our members were before executive appointments last week, and Catherine, by the way, is having surgery Thursday on a hip, and she's going to be out of commission for 6 weeks. So fell over her dog.
Oh.
Poor thing. But congratulations to everyone, and thank you for helping maneuver that as well. So,
I do anticipate those being all mentioned today.
okay, cool. All right. We will go on. Bernadette, next up. Thank you.
Yeah,
Brian.
so the next item's an informational item. As a reminder, the board last month gave staff the authority to certify these results, since the results were the canvas would come in and we would need to certify ahead of this meeting. So this is just an informational item of the canvas of results for the consolidated election, April 1st, 2025, for the Fox Waterway Agency and Fox Water Reclamation District.
Do we need to do something specific?
No
This
motion, no
information?
action.
All right.
Simply informational.
Wonder why they get such special. Waterway. All right. Go on.
And then next is a 6-month review of executive session minutes. So as noted in the memo, Marnie and I reviewed the minutes of the executive sessions for the period of October 16th, 2024 through March 18th, 2025, and have concluded that necessity of confidentiality does not exist as to the minutes, except for the 2 exceptions. Well, it's 3 executive session exceptions noted in the memo. So we are requesting a motion from the board to approve the release of the minutes with the exceptions that are noted in the memo.
I have a motion to that effect.
So moved.
Second?
Roll call in.
Ms. Bella Croft,
Yes.
Ms. Craig.
Yes.
Mr. Navasi,
Yes.
Ms.
Oh,
McCory.
wrong one. Yeah. Okay. We got it.
Mr. Turbin,
Yes.
Mr. Brett,
Yes.
Vice Chair Donahue,
Yes.
Chair Watson.
yes,
Motion passed.
Okay, thank you. The remaining items of voter registration activity, grant funding update, FY25 fiscal status reports, and the 2-year plan of staff activity for the months of May and June are informational. I did just want to note for the grant funding update that the deadline for jurisdictions to submit for reimbursement on the grants that are outlined in the one memo, it's mid-June. So many of those jurisdictions do wait until that deadline. So we do believe those numbers are going to change. We'll have a more accurate accounting in July once that period for reimbursement closes in June.
All right. Thank you for that, Bernadette. Anything else?
Nothing else from me.
Is there any other business to come before the board? All right, we have 2 people who, under general comments, general public comments, and I believe they're both in Chicago. Do you have 2 people up there?
We have one person.
Do you have one here? Did Miss Marks? Okay. Is it Nancy or Kathleen?
Kathleen? Kathleen.
All right. Kathleen, you have 5 minutes. Please state your name, spell it for the court reporter, if you will, please.
Kathleen Gilroy, KATHLEEN GILROY. I'm a member of the public and former DuPage County election judge. I'm speaking to you today about the failure of the DuPage County Board of Elections to follow the Illinois Election Code. I believe that I am following the proper chain of command in speaking to you. because 10 ILCS 5/1A-8 states that your duty is, quote, to report violations of election laws to the appropriate state's attorney or the attorney general, unquote. After I called DuPage County to report a violation of election law by judges who considered themselves in charge, my colleague and I discovered that we were not getting any notifications or responses to emails or phone inquiries to DuPage County. Then I received a termination letter from the county more than a year after I filed my complaint. My colleague was simply ghosted. We went directly to the office of the DuPage County Board of Elections and spoke with the person who took my complaint. She acted mystified. We requested a meeting with her boss. We spoke with him by phone only once. We spoke with the Citizen Advocacy Center, our senator, township organizations, county board members, and sheriff. It wasn't until we did FOIA requests that we discovered that we had been subjected to a malicious campaign of false complaints by 3 judges who had violated Illinois election law. These judges filed 4 separate defamatory statements against me in the year before I received the termination letter, a year that I didn't even work as an election judge. When I made a FOIA request for all documents relating to my service as an election judge, the response did not include the complaint I made, nor did it include my letter of termination. No one asked our side of the story, nor was any form of investigation done. We reapplied as election judges. According to the Illinois Election Code 10 ILCS 5/13-3, the quote circuit court shall enter an order that cause be shown, if any exists, against the confirmation and appointment of such persons, unquote. The code also states, quote, in the event that any judge of election is removed for cause, the board shall specify such cause in writing and make such writing a matter of public record, unquote. Furthermore, quote, if objections to the appointment of any judge be filed prior to the day fixed by the court for confirmation of judges, the court shall hear such objection and the evidence introduced in support thereof, and shall confirm or refuse to confirm such nominations as the interests of the public may require, unquote. In conclusion, staff at DuPage County are acting like schoolgirls and acting on untrue rumors. The 7 tests for just cause of an employer noted in 1966 by Carol R. Dougherty are 1, reasonable rules and orders, 2, notice, 3, investigation, 4, fairness of the investigation, 5, proof, 6, equal treatment, and 7, fairness of the penalty. I expect a county government agency to be more mindful of model employment practices than some random business employer. Not only were none of these 7 tests done, multiple FOIA requests still didn't reveal the full picture of why we were treated so poorly. I have talked to a reporter and we have considered obtaining a lawyer. We are requesting that our records be purged of malicious gossip and that the perpetrators of the bullying, harassment, and retaliation be punished accordingly by being terminated themselves, as their violations of election law make them unworthy to serve as election judges. We have violated no laws. We have, however, suffered monetary damages by being unable to earn the income we had expected by serving as election judges and by the time and effort we have expended to clear our names. I'm submitting my full complaint in writing. Thank you.
Thank you very much, Ms. Gilroy. We appreciate your comments.
My suggestion would be to talk to the state's attorney of the county. They're responsible for that county's legal compliance. That would be your best bet.
Yeah, I mean,
Isn't that what the board, the code says the board does that? We've been to every place except the state's attorney and the attorney general.
yeah, no, we have 108 local jurisdictions, election authorities. And,
They're all autonomous.
they're all individuals, they're all autonomous in and of themselves. So it's your local authority that law enforcement that you've got to go to.
But we'll review the complaints, of
Yeah,
course.
I mean, leave it with, Andy, I think you're up there.
Yes.
Thank you.
So we'll review it, but I would suggest very definitely that you talk to your state's attorney. It's hard to get election judges, so it's, it's like, whoa. All right. No, I have two lists, but they said there was only one person. So is there any other comments by the general public?
That was my colleague, but it said you wouldn't accept two people, you know, at the same time.
We have reason to believe the other person was the other election judge in Kathleen's complaint.
No problem. We appreciate it and we do, thank you for your effort, Ms. Gilroy, truly. All right. Now, we've got to go back into executive session. All right, we need to clear the room up in Chicago. I'm here and I'll have a motion to,
If there's a motion to go into executive session for the purpose of discussing the minutes of the April 15th executive session meeting and pending litigation pursuant to sections, are we also talking about an employee matter?
You can just add it.
Okay, and employee matter pursuant to, bear with me for 1 second. Looks like I had the old outdated agenda. Okay, so the purpose of the executive session is to discuss the appointment, employment, compensation, performance, or dismissal of specific employees, pending litigation, and the minutes of the April 15th executive session meeting pursuant to section 2C1, C11, and C21 of the Open Meetings Act.
all right, do I have a motion to that effect?
So moved.
No, second, in a second. Moved and seconded. Amy, roll call, please.
Ms. Malloy-Croft,
Yes.
Ms. Craig.
Yeah.
Ms. Genovese,
Yes.
Ms. McCrory.
Yes,
Mr. Turbin,
Yes.
Mr. Brett,
Yes.
Vice Chair Donahue.
yes.